Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome day. Hey, so I know I've been off the scene for a minute, but sometimes you need a break from YouTube. But in my spare time, I do like to read and I like to read court docs. So why not get back into the Buzbee Jay-Z thing, right? So I was able to pull the declaration for Buzbee's attorney, Miss Vasquez, who was Johnny Depp's attorney. I was able to pull the private investigators. We already done Charlotte's, but James Butler, the other investigator that was there with her, who spoke with Jane Doe. I was also able to get Ian Pillinger's declaration, as well as the attorney Robert Swartz, who is actually Jay Z's attorney in this case. In addition to that, he included the transcript from the motion hearing, the motion to strike hearing that took place on February 25th. And specifically in that hearing, this is what everybody was reporting on. They stated that the judge was only going to consider two of the defamation statements out of the 4 to 6 statements that Busby made, Jay Z made, or claimed that Busby said that Jay Z ended up putting in his amended complaint. So that's that. As far as the extortion, he says, really, there's no evidence of extortion. And he said, if you're considering the demand letters as evidence, you can throw that out the window, pretty much. So that's gone. Uh, what we're going to tap in is the declarations, but first, I want to read a part of the transcript from the hearing on the 25th because I do find something interesting. We know the timeline of these declarations, or when the private investigators spoke with Jane Doe. Keep in mind, in the declaration for the private investigator stated that she spoke with Jane Doe on February 21st. So that would have been before the February 25th hearing. So pay attention to what the attorney is telling the judge when the judge is asking him questions about who the private investigator spoke with. So be mindful. The private investigator said they spoke with Jane Doe on the 21st. Now, Jane Doe submitted her declaration. She signed hers on the 27th, which was 2 days after this motion hearing, and it was filed with as a declaration in support of Tony Buzbee's motion to strike Jay-Z's amended complaint. So be mindful of the dates. Be mindful of what the attorney, Jay-Z's attorney, Mr. Swartz, is telling the court. So let's tap right into this transcript right quick. I had to highlight it because it's 101 pages, but I think this specific uh few pages is it's really going to make sense. So let me see. Okay, so here they're talking about the evidence. The judge is wanting to know what new evidence the plaintiff Jay-Z has. That's the conversation. Mr. Swartz, that is Jay-Z's attorney. This is what he says. I've told you all I know to this point, that the investigator let me cut through this for a second and suggest a way that we could handle this for your consideration, Your Honor. Because the judge at this point, he was like, look, either you have evidence, and if so, Y'all need to call them right now and let me know what y'all got, because I'm not about to, go on and on and on and on about this and y'all don't have anything. So just listen. I I'm in here not just with one hand tied behind my back because I'm the plaintiff and I've got two hands behind my back. I'm in here. I'm trying to engage with the court, and colleagues are running around outside of court investigating, talking to people, gathering information, and it's like, look, I need to get to the bottom of this, and I would like a little time to do that and present something to the court, either in the form of just sort of brainstorming here out loud, which is a dangerous thing to do. But maybe we should be doing is giving us a couple, let's say until Monday or Tuesday, to file an ex parte application for leave to conduct limited discovery. We would attach the information we have from the investigator and say we'd like to depose the person the investigator spoke to so that we eliminate the hearsay objection. Because now the hearsay, oh my gosh, I probably need to go back and show y'all the hearsay, but pretty much what he's saying, the judge clearly said, don't come into court with something saying, okay, the investigator said that they spoke with this person that said that Buzbee said this, because that would be considered hearsay. Okay. Um, Listen to what the court says. The court says, I guess the problem is I'd like to know what the investigator, I would think that somebody at your office would know what the investigator will say, not necessarily the person the investigator spoke to, because they haven't spoken. Only the investigator has spoken to that person. But you ought to know, or someone at your office ought to know, the investigator is going to say this. The investigator is going to say, I spoke to names, not I spoke to John Roe. I spoke to names who told me X. I think you ought to know, and you ought to know it now. So the judge is like saying, look, if you're saying that your investigators are already out speaking to people, then there should be no problem of us taking a 5-minute recess, you calling the investigators or somebody at your office to get in contact with the investigators and say, hey, who did you speak with? Y'all catching on? All right. So Mr. Score says, right. Schwartz, I said Schwartz. Schwartz says, right. Then the judge says this. And so if we need to take a short break so you can get it, I'm willing to do that. And then we could come back in a few minutes. But before we start by derailing everything, I need to know that there's some reason to derail it. I'm not going to stop the train unless there's another train coming down the tracks. So if you can get that, and if it's strong enough, then the arguments, we can talk about it. But I understand them. If the thing I'm going to get from the investigator is I spoke to somebody whose name I'm not going to tell you, who spoke to Mr. Buzbee, or spoke to someone who spoke to Mr. Buzbee, I'm not sure, who said that the letters were probably not as strong as he wished they were, you're not going to get anything. I'm not going there. Mr. Score says, right. The judge then says this. Then let's just rip off the band aid and have this motion granted, denied, or granted in part, denied in part, and move on. If what you've got is, I spoke to Bill Smith, my favorite hypothetical person, and Bill Smith told me that Buzbee said, I wrote those letters without any client authority and the clients were not clear that they ever wanted to sue, now we got something. So keep in mind what we read in that Charlotte Henderson declaration in the petition that Jay-Z filed in Alabama. Okay, I'm going to read that part what the court said again. He said, I spoke to Bill Smith, and Bill Smith told me that Buzbee said, I wrote those letters without any client authority and the clients were not clear that they ever wanted to sue. Now we got something. So in those declarations, they pretty much stated that they never wanted to move forward with suing Jay-Z, and it was all Buzbee that wanted them to include Buzbee in there and sue. Jay-Z's attorney says, right, I am concerned that I'm going to be told that the investigator was, that you're not going to be happy with the information I give you because the investigator is going to say, I can't give you the name of the person I spoke to. They spoke to me on the condition that blank. Now, I am assuming that he was trying to buy time just based off of this because they already knew that they were going after Jane Doe. They already knew that they were going to go after Jane Doe, um, because that they, who else would they go after? It's going to be Jane Doe and it's going to be John Doe. I have yet to hear anything about John Doe, but we're gonna continue. The court then says, well, then how do you think that you're going to get through Sweetwater or the investigator and take the deposition of a person unknown? And Sweetwater, that is the case that they are uh Sweetwater is kind of like the guidelines of how they are going to go through this. And that's a whole nother lie that we can talk about. The attorney then says, well, I'm assuming, Your Honor, that if we are and we are able to find that out, what I am telling you is right now I have concerns that I can't satisfy Your Honor and we should just move forward. The court says, okay, it could be, but my concern is now that you're telling me is I have hearsay from an unnamed declarant who the investigator will not name and who will not go on record, but I am not able to firm that up because I might be able to do what? Send a subpoena to the investigator and depose the investigator under oath, get some declarant who doesn't want to go on record. You think the declarant is really going to say, is going to be happy with you and the investigator if that happens? I think you're going to have a declarant who suddenly is going to have a frightful bout of amnesia if my 30 years before becoming on the bench are any guide. You have a declarant who says, I'm not willing to go on the record, and the investigator says, well, that's too bad. I've given your name up, and now everyone is going to depose you, and the press won't be there, but they're going to see the declaration. Hope you don't mind. Jay-Z's attorney says, no, I think, and then the court says, you're going to get, sure, I swear to tell the truth. I don't remember anything in my name. I don't remember it. The attorney says, yes, I don't think it's that. I think that if our hand wasn't tied behind our back, I would talk to the investigator. I would get the information. I would be able to do it. What I'm saying is, my concern is that the next 10 minutes is not going to happen. And therefore, I think we should proceed. So what he's saying, if he calls the investigator, now this is February 25th. If he called the investigator, right? Why couldn't the investigator say, hey, I spoke with Jane Doe? If they indeed spoke with Jane Doe on the 21st. Now, they both agreed, Jane Doe and the investigator stated that, they all spoke on the 21st, but I don't understand how is it that if the judge said, call them right now in this court and ask the investigator who is the person, he couldn't do it. It just didn't make sense to me right here. The court then says, all right, let's do this. Let's proceed on the evidence we have. What I will likely do, just because I was probably going to do it anyways, is take the matter under submission at the end of the day. And if after that you get what you think is sufficient evidence, you can do what you feel you need or want to do, and we'll figure it out. That doesn't mean that I'm going to continue the hearing or let you file new evidence. But if you want to file some sort of request, you can do it. I'd work with the other side to see if you can agree on a procedure because I'm more likely to let it happen if the parties agree on a procedure and we'll figure it out. So let's move forward today on the evidence we have today. And given that who I guess I'll start is a mixed bag, so I'll start with the moving party. So that's that part. Okay. Now, going to I'm going to tap into Vasquez. So I think that's how you say it. Camille Vasquez, Johnny Depp's attorney, submitted her declaration the same day that Jane Doe's declaration has been submitted, and this is what it reads. So she is a partner with Shepard Mullen, and she is the attorney for the Buzbee law firm and Tony Buzbee. And she states, if I am called as a witness, I could and would competently testify to all facts within my personal knowledge, except where stated upon information and belief. On Tuesday, February 25th, 2025, a hearing was held before the above entitled court on the Buzbee party's special motion to strike. The complaint filed by Sean Carter in the above captioned action. At the hearing, counsel for Carter indicated to the court that his office was just the morning come into possession of new evidence material to the motion and requested a continuance of a few days to allow the evidence to be presented to the court, proposing that the motion could proceed with a hearing on the following Monday, March 3rd, 2025. Counsel for Carter also suggested that the evidence might indicate that the demand letters underlying this action were sent without authorization. The court proceeded with the hearing, but indicated that Carter could file an application to augment the record on the motion. 3 days later, on February 28, 2025, a meet and confer was held via Zoom between my office and counsel for Carter. During this conference, counsel for Carter proposed a schedule for which Carter would file an application to add new evidence on Tuesday, March 4th, 2025. We asked counsel for Carter to describe the new evidence that would be the subject of the application. Counsel indicated that she was unable to provide any new details about such evidence, but that she expected to have more information the following Monday. Accordingly, the meet and confer was moved to Monday at 10:30 a.m., the date previously suggested by counsel as the continued date of the hearing on the motion, to allow counsel for Carter time to gather information about the offered new evidence. Now, on the morning of Monday, March 3rd, 2025, counsel for Carter advised via U.S. email that she needed to postpone the meet and confer to the following day. To date, 6 days after Carter counsel represented that it was in possession of new evidence that would materially change the court's analysis of the motion, no further description of the new evidence has been provided. In the intervening time, the Buzbee parties have provided with a declaration from their client Jane Doe in the underlying case that was filed against Carter in New York, which responds to the pro-offer new evidence, which is being submitted to the court currently herein. And that's what we read. Jane Doe's declaration that stated that they approached her, but they have been stalking her, her parents, trying to get information, trying to get her to sign an affidavit. Now, mind you guys, oh man, I should have wait, hold on. Let me jump to Charlotte's. I think Jane Doe also said that on February 21st. But either way, that is what Robert Squartz was relying on. They were banking on Jane Doe signing an affidavit or a declaration to submit, but it didn't happen. It did not happen. Instead, she filed her declaration to support Buzbee's to motion to strike Jay-Z's amended complaint. But mind you, the declaration of Jane Doe was she did her declaration on the 27th. It was just filed with the declaration of Miss Vasquez on the 3rd. That was the deadline. Now, we read Charlotte's, right? So look at this, y'all. So this is Charlotte's. It is pretty much verbatim. It is verbatim. James Butler's declaration is verbatim to Charlotte's. The only thing that I questioned is this part right here. And I know what they did. I know what they did. So you have 9 and then you have I declare under penalty of perjury. All they did was copied and paste this declaration onto this language right here. So this part right here, see, even if I did that, you see how I can click it? They just copied and pasted this one. So they took this, changed whatever words, and then as far as the signature page, they just went ahead and pasted that on there. Yes, my job is to look at stuff like this. But anywho's going to James Butler. So James Butler is the investigator that went with Charlotte. He states, and I'm not going to go over because they pretty much say the same thing. He just states that on February 21st, along with Charlotte, he met with Jane Doe. They said that, they're going to protect her privacy and her identity, not disclosing any other factors or her name or anything of that language. He also mentioned same thing that Charlotte says, that Miss Doe's body language included her nodding, was a relaxed posture, steady tone of voice, reinforced she didn't feel scared or intimidated during their interaction. Pretty much the exact same thing that Charlotte Henderson said. The only difference is that right here it says Miss Doe, Miss Henderson, and I were the only people present. And then here it says that Miss Doe, Mr. Butler, and I. That's the only thing that changed. Nothing changed. All they did was took this out and entered Mr. Butler's information there. All right. Now, let's tap into Mr. Ian. Mr. Ian, I don't even know who this is, but we're about to find out. Let's see. All right. So, okay. So, Mr. Ian is an employee of Guidepost Solutions LLC, which is licensed to conduct investigations in the state of New York. He was provided with the name of Jane Doe. The person, we already know who that is. And based on publicly available records and internet searches, this investigation revealed the following information about Jane Doe. To protect Miss Doe's privacy and identity, I am not disclosing her name. So you were provided the name of Jane Doe. Now, what I don't see in here is I don't see dates as far as when you were provided her name, because her name is confidential under the protective order. Now, I don't know, once a case, if it has been dismissed with prejudice, if her name is automatically, released. I don't know that information, because sometimes you can have a protective order so many days afterwards that says, okay, you can't release the names. But I don't see them just saying, hey, here's her name because the case is over. But one thing I don't see is that when you were provided that name, that does play a role. That makes a difference. So he got her name. And he states the following: Jane Doe has a legally documented history of mental illness issues. Her parents have custody over her son, and she lost custody over her daughter because an Alabama court determined that Doe has engaged in a series of activities, both before and after the child's birth, that the court found to be inconsistent with someone demonstrating good mental health. According to the court in that case, Jane Doe has a history of bipolar disorder, borderline personality disorder, obsessive compulsive disorder, and psychogenetic non epileptic seizures. Jane Doe's doctor gave a deposition in that case, a transcript of which is publicly available, in which the doctor stated that Jane Doe has a history of auditory hallucinations, that is, hearing voices that other people don't hear. Jane Doe was in a mental health facility less than 90 days before the defendants in this case sent their demand letter. She has recently been under the care of a psychologist. She regularly posts on social media, including on Facebook, Instagram, and TikTok, about the difficulties she has living with her conditions. She alleged in a child custody case that the unwed father of one of her children believed he was Jesus Christ. Jane Doe also has a criminal history. In 2023, Jane Doe was indicted on a charge of assaulting and causing a physical injury to a detention officer. She was released on bond, but she has uh, thrice since her bond revoked because she failed two drug tests and tampered with a third. Most recently, she failed a drug test on, I said it. At this point, I guess I could just say it. On August 19, 2024, which caused her case to be transferred from mental health court back to district court. Earlier in 2023, Jane Doe was charged with the assault with bodily fluids. In 2022, she pled guilty to unlawfully using or possessing drug paraphernalia. Jane Doe has accused at least four people other than Mr. Carter of sexual assault. Jane Doe accused someone of sexual assault and of branding her on the cheek, but the court dismissed that claim. In a social media post, Jane Doe said that she was a victim of sexual abuse when she was 6 years old. According to her ex husband, Jane Doe falsely accused the ex husband of M wording the daughter they have together. She also accused the man on social media of seeking photos of children in exchange of money and posted a picture of his face. She posted on social media regarding a separate incident where someone alleged carved the word freak into her chest against her will. And he made this declaration and submitted it on March 4th, 2025. So that is Ian Pillinger. I believe that there was another declaration. Hold on, let me see. And this is Miss Mary Henderson. Let me see who she is. Okay, so she's just talking about the ex parte application of this new evidence. So that are the declarations. So I want y'all know we like to engage in healthy uh conversations in the chat. So by me reading what the judge stated in regards to what he is going to consider as new information, what can be admissible in court, not hearsay, but admissible, and then me reading the declarations of the investigators as well as the declaration of Ian. What do you guys think about this? Do you believe that I think that they're using this as the new evidence. This is what they're saying is their new evidence. The declaration from the investigators stating that one, Jane Doe said that Buzbee made her do it, or, made her include Jay Z. And then two, the new evidence is Jane Doe has a criminal history and she has a history of mental health issues. Therefore, she could have been easily manipulated, or she's making this stuff up because she has a history of making. I believe that they believe, and I'm speaking on the plaintiff, Jay-Z and his attorneys, they believe that this is considered new evidence. I don't think that is going to slide with the court, but We shall see. The next hearing is on March 26th. So we have what, 14 more days? We have about 2 weeks before we get a true answer as to what they consider new evidence and what the judge will actually consider as new evidence. They also, I am probably going to do another live in regards to the what they objected to. That's a whole different live. I'm not even gonna get into the, but y'all let me know what y'all think about these declarations. Everybody is on the fence about this. I'm focused on the timeline. I'm like, okay, you met with her on the 25th, on the 21st, on the 25th, you guys had a hearing. The judge says, I need the names. I need the name of the individual who your investigator is talking to that will be willing to say that Buzbee pretty much knew that the contents of the demand letters in this lawsuit was frivolous, but yet nothing was presented that day. But then we have, fast forward to the third, now we have all these declarations coming in. So I want to know your thoughts. Put them in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.